días, sean todos muy bienvenidos. Gracias por estar aquí conectados y presentes en esta nueva virtualidad que cada día la tenemos más incorporado en cada uno de nosotros. Ante todo quiero agradecer a todos los que se han conectado. Tenemos personas conectadas de distintos lugares, no solamente de Chile, sino también de Argentina, Estados Unidos, otros países de Latinoamérica. La verdad que es un placer para mí poder acompañar a esta actividad y a estos panelistas que también nos acompañan, y quiero agradecer enormemente a Jamie, Pelayo, Collin y Mike. Aquellos que no me conocen, mi nombre es Gabriel Calgaro. Yo no soy del mundo de las leyes, no soy del mundo de la justicia. Llevo 30 años en el mundo de la tecnología y realmente me pone muy contento ver cómo la tecnología ha generado altos impactos en estos últimos años. He visto toda la evolución por muchas industrias y creo que la justicia y este tema del mundo legal, reclamos, ODR y lo que vamos a ver el día de hoy, era alguna asignatura que tal vez está un poquito más retrasada. En el día de hoy básicamente vamos a tener 4 panelistas, alrededor de cada uno va a estar hablando unos 15 minutos, para que luego después hagamos una sesión de preguntas y respuestas. Así que bueno, para no demorar más la agenda, quiero dar entrada a nuestro primer panelista, un gran amigo, Pelayo Covarrubias. Pelayo es presidente de País Digital y también es director de Alianzas Estratégicas de la Universidad de Desarrollo aquí en Chile. Quiero dar un especial agradecimiento a Pelayo porque, bueno, yo también soy miembro del directorio y me da mucho placer compartir muchas actividades con él. Y bueno, la semana que viene se realiza el Summit de País Digital, que es un evento que se va a llevar a cabo el día 1 y 2 de septiembre, con lo cual sé que Pelayo está entre agenda y agenda, así que se dio el espacio para estar aquí con nosotros. Y un poco la invitación a Pelayo como fundación, que el trabajo siempre ha sido ver cómo se achicaba este puente digital entre la sociedad y el mundo académico y el mundo privado. Me parecía muy oportuno hacer como una pequeña introducción de cuál es su visión en estos últimos 10 años en la Fundación acerca del impacto que tiene la tecnología en cada uno de nosotros y en cada una de las ciudades. Así que, Pelayo, todo tuyo.
Muchas gracias, Gabriel. Muchas gracias a todos por esta invitación. Quiero especialmente agradecer, porque la verdad que, como bien decía Gabriel, este es un tema que hoy día nos apasiona y estamos en la mitad, a propósito del COVID, de una transformación digital que el mundo está teniendo con mucha fuerza. Quiero partir agradeciendo a SIV Abogados por esta invitación, a NatLaw y a ODR Chile. Y la verdad que para responder la primera pregunta que nos hacía Gabriel, yo creo que es interesante, les traje una pequeña presentación de mirar un poquito cómo está Chile en el ámbito de la conectividad, en el ámbito de la Internet, en el ámbito de la economía digital. Les voy a compartir una presentación por algunos minutos, 30 segundos. Ahí. ¿Por qué yo creo que es tan importante hablar de esto hoy día? Y a propósito de las ODR y de alguna manera de la resolución de estas disputas mediante nuevas tecnologías, que es un tema novedoso en el mundo y naturalmente en Chile también. Yo creo que hay que entender por qué está llegando hoy y por qué probablemente se va a acelerar más que nunca a partir de lo que hemos vivido producto de la pandemia. Bueno, ¿qué sucede de alguna manera en Chile? Les quise traer un poquito parte de una historia. Yo creo que es importante entender cómo el país ha venido creciendo en los últimos años en el uso de Internet. Hoy día estamos llegando cercano al 80% de la población y hay una gran diferencia entre lo que es la conectividad móvil y lo que es la conectividad fija. Probablemente hoy día tenemos del orden del 97-98% en conectividad móvil, es decir, de hecho, a través de un proyecto que hacemos con el gobierno que se llama Compromiso País, sabemos que hay 320 localidades que solamente no tienen conectividad en Chile, localidades muy chiquititas del orden de 50. Pero en lo que se refiere a conectividad inalámbrica, técnicamente tenemos el 100% del país, y eso ha sido un gran avance para la necesidad de que estas tecnologías se puedan ir ocupando de manera masiva. Ahora, el desafío está en la red fija. En la red fija todavía en Chile tenemos solamente un 52% de hogares conectados con red fija. Y muchas veces nos ha pasado a partir de la experiencia que hemos tenido en la pandemia que la capilaridad de esa red es la que tenemos que empujar con mucho más fuerza para seguir adaptando nuevas tecnologías que nos permitan ir llegando. Pero lo que les quería comentar no iba tanto en la lógica de la conectividad, sino más bien yo empiezo a mirar, bueno, cómo estamos en la lógica del uso de la conectividad que hoy día existe. Y acá les quiero reflejar un primer punto. Si ustedes miran, técnicamente en los últimos 7, 8 años se ocupa los buscadores. Bien, hay uso en la economía nacional para eso. Hay uso en el entretenimiento nacional, es decir, la gente lo está ocupando la Internet como una forma de buscar oportunidades de entretenimiento. También lo vemos, pero a una tasa mucho menor que lo que veíamos recién, para la compra y venta de artículos. Es más, si yo miro el 2020, y esta es una alza que hemos puesto producto del coronavirus, porque hemos estado haciendo estadísticas online desde País Digital, vemos el salto que se pegó, lo mismo por ejemplo en Estados Unidos, el e-commerce en Estados Unidos a fines del 2019 era del orden del 18%, se esperaba que al 2025 llegara del orden del 24%, pero se pegó un salto al orden del 40%. Por lo tanto, esto naturalmente va a generar un cambio en el uso de tecnologías como los que vamos a hablar más adelante en el ámbito de las disputas. Desde el punto de vista de cómo estamos ocupando la banca a propósito de las tecnologías, lo mismo, ustedes ven que a tasas muy distintas al uso de entretenimiento, la banca ha venido creciendo, ya estamos en el orden del 50%. Pero ¿por qué quise traer esto primero? Porque es muy importante, Gabriel, que entendamos que los cambios culturales que implican estas transformaciones digitales, para que toda la población sea capaz de adoptar nuevas tecnologías, requieren ciertos tiempos. Y creo que hoy día este seminario está siendo fundamental, porque yo estoy seguro que vamos a pegarnos un salto muy grande en el Chile de los futuros en mecanismos de resolución de controversias como los que ustedes están planteando a partir de las tecnologías que han desarrollado ya maduramente en Estados Unidos. ¿Qué sucede? Y si uno mira también el uso de las capacitaciones, ustedes ven que todavía el nivel de uso de las tecnologías disponibles para capacitarnos es poco. Ahora bien, ¿qué pasa en Chile? En el ámbito de las instituciones públicas. Y hemos venido empujando con mucha fuerza la digitalización de los trámites. Ya les voy a hablar más adelante del porcentaje de trámites que está digitalizado. Pero todavía tenemos que pegarnos un salto, y esto es muy interesante para conectar con lo que ustedes están empujando, porque de alguna manera muestra cuánto del país entiende en trámites el uso de herramientas como las que ustedes están de alguna manera trabajando. Ahora, en Chile tenemos, siempre hablamos nosotros desde Fundación País Digital, y esto a partir de un estudio que toma una encuesta nacional que se hace en Chile, ¿cuáles son las grandes brechas que tenemos en el ámbito de la digitalización? Y hay 4 grandes brechas. La primera es una brecha naturalmente socioeconómica, hay diferentes realidades socioeconómicas en distintas partes de este largo y gran país. 2, las etarias, naturalmente a mayor edad menos uso de Internet. 3, entre lo residencial urbano y lo residencial rural, sin duda hay una diferencia. Y 4, educacional. ¿Y por qué les quise traer esto también como elemento fundante del diagnóstico de cómo está Chile preparado para enfrentar desarrollos tecnológicos como los que ustedes nos están mostrando? Bueno, porque miren las diferencias. Miren en el mundo urbano y en el mundo rural la diferencia de usos. Naturalmente es en ese diagnóstico la penetración de tecnologías como las que ustedes nos van a contar más adelante tienen diferencia, y nosotros estamos esperando hacia el Chile del 2025, y esta es una propuesta que está haciéndole Fundación País Digital al país, tener 100% urbano y 100% rural. Esa es la meta que nos hemos colocado como país. Si ustedes lo miran en el ámbito de la educación, miren las diferencias, y hemos visto, todos los chilenos que están probablemente escuchando, diferencias que hemos visto, brechas que se han producido en temas rurales o temas urbanos a partir de la pandemia del coronavirus. Desde el punto de vista instituciones públicas, exactamente lo mismo. Muchas veces nos duele el estómago cuando vemos a gente haciendo filas presenciales para poder ir sacando ciertos trámites. Bueno, aquí ustedes pueden ver y refleja de alguna manera el diagnóstico de cuánto es el uso que yo estoy teniendo a partir de la conectividad en temas de trámites que son tan necesarios en el Chile de hoy. Y aquí quise mostrarnos para que se queden pegados en el cuadro, pero naturalmente hay una gran diferencia a nivel educacional. Si ustedes miran la gente que tiene posgrados completos, educación completa, el uso es del 100%, versus, ojo, no nos olvidemos que el 50% del país tiene hasta cuarto medio, y ahí el uso todavía es muy bajo. Entonces, cuando estamos hablando de las brechas sin duda son distintas, no solamente son socioeconómicas, de hecho el país es tremendamente competitivo en capacidad de redes y, ojo, en precios. Chile está dentro de los 5 países más baratos de banda ancha y de banda móvil. Eso nos hace un país tremendamente competitivo en el uso de tecnología. pero tenemos otros desafíos que a veces se nos olvidan que son aún más importantes, como hablaba el etario, el educacional, el físico, urbano, rural. Entonces, de alguna manera, Gabriel, quiero dejar expresado que hoy día nosotros estamos enfrentando 4 grandes desafíos. Sin duda, educación. Ya lo hemos comentado, no es materia de este panel, pero es un tema fundamental para poder dar el salto en la economía digital. 2, modernización del Estado, que me voy a meter un poco más. 3, regulación, que es un tema fundamental para lo que vamos a hablar hoy día. Y 4, el ámbito de las empresas, que no lo voy a tocar, pero que es un elemento fundante, naturalmente, en que la medida que las empresas se digitalicen mucho más, van a ser capaces de tener las tecnologías que ustedes les están ofreciendo, producto de que el salto en el mundo del e-commerce va a ser mucho más importante. Y esto, naturalmente, con un cruce transversal de lo que es la infraestructura que les acabo de comentar, digital, que estamos bien en Chile, pero tenemos el desafío de saltar en el ámbito de la conectividad física, y 2, en el ámbito de la ciberseguridad, que tiene que atravesar permanentemente todo. ¿Qué hemos estado haciendo? Bueno, hemos estado trabajando con mucha fuerza con el gobierno, a través de la Secretaría General de la Presidencia, y ustedes pueden ver que hemos definido muchos elementos que son fundantes para poder trabajar con más fuerza, disminuyendo los trámites, acelerando de alguna manera lo que es la arquitectura del gobierno, permitiendo al gobierno tener una administración mucho más inteligente. En esto, el presidente Piñera, en los últimos 2 summits, como bien comentaba Gabriel recién, la próxima semana tenemos el Summit 2020, pero ya en el Summit del 2018 y en el Summit del 2019, él le planteaba al país el cómo está empujando la transformación digital que el país necesita para que vayamos acelerando estos procesos. Y hemos visto a partir de distintas brechas, las brechas en investigación y desarrollo, las brechas en ciencia, las brechas en conectividad, poder ser capaces de modernizar con mucha fuerza el rol del gobierno. Por eso les traje estas 2 láminas de alguna manera, porque ustedes puedan ver que el gobierno está comprometido con acelerar este proceso de transformación digital. Sin duda tenemos que agregarle mucha urgencia y mucha institucionalidad para hacerlo más rápido y con más fuerza, pero se está trabajando. Y la pregunta entonces que nos hacemos, y esto es a partir de un estudio que hicimos en conjunto con Cisco, durante el año pasado, a principios de este año fue lanzado, digamos, gracias a un gran empuje de Gabriel en su minuto, fue bueno, ¿cómo estamos preparados a diferentes regiones a nivel nacional? Y es bien interesante ver que tenemos también grandes diferencias. No es lo mismo estar en la región metropolitana que estar en la región de los ríos, por poner un ejemplo, y vemos las diferencias que hay. Y esas diferencias se van viendo a partir de los distintos elementos que involucran una gran transformación digital. A veces cuando hablamos de economía digital solamente hablamos de la infraestructura tecnológica, y no es eso. Para mí aún mucho más importante que la infraestructura tecnológica, que es basal, la adopción tecnológica y que seamos capaces de adoptar las nuevas tecnologías, el capital humano que hablábamos recientemente y la importancia de ir desarrollándonos en esa mirada, el tener como país las necesidades básicas cubiertas de forma que nos podamos pegar el salto a lo que implica las facilidades del comercio. Y aquí en el e-commerce, yo creo que vamos a poder hablar en las preguntas y respuestas, Gabriel, de la importancia de elementos como los ODR y cómo estos softwares son capaces de apoyarnos en esta gestión de elementos de controversia. La inversión privada y la inversión pública que estamos manteniendo en estos temas, y naturalmente este clima emprendedor que nos ayuda a innovar, y ahí probablemente discutiendo la regulación y siendo capaces de liberar y flexibilizar con mucha competencia los distintos elementos que estemos trabajando. Como les dije delante, creo que esta lámina era interesante porque el tema de los trámites y la digitalización de los trámites del Estado es un tema que ha venido avanzando. Nosotros como Fundación País Digital nos habíamos puesto una meta, que era llegar a un 100% al 2020. Como ustedes ven, no la hemos cumplido, pero estamos avanzando, estamos al 68% este año y esperemos ya durante el próximo año poder llegar al 100% de los trámites digitalizados. Y de alguna manera lo que ustedes nos van a plantear durante el seminario son tecnologías que van a ser muy importantes para ayudarnos en este proceso. Ya teniendo el 100% de los trámites digitalizados, también tener tecnologías as a service que nos ayuden a resolver ciertas disputas y problemas que estamos viendo de alguna manera. ¿Qué sucede? Que yo creo que el COVID aceleró todo lo que estamos conversando. Como ustedes lo pueden ver en esta lámina, de alguna manera, somos capaces de entender que Chile y el mundo se tuvo que ir a este laboratorio digital. Y en este laboratorio digital que estamos viviendo, hemos todos aprendido a vivir a distancia de manera distinta. Y por lo tanto, las tecnologías que ustedes nos van a mostrar, probablemente hoy día en la cultura nacional, en la transformación cultural tan necesaria, están más preparadas para llegar al cambio que se necesita y para poder adoptarlas. ¿Y por qué me parece tan relevante hoy día? Porque como les pongo acá, yo creo que tenemos una oportunidad hoy día, a partir de la recuperación económica que hay en Chile, post-COVID, el introducir con mucha fuerza esta opción tecnológica. Entonces me parece más relevante que nunca que hoy podamos discutir y conversar sobre estas herramientas que se están trabajando. Sin duda hoy día en Chile las hay, ya hay instituciones que la han desarrollado. Pienso en la Cámara de Comercio de Santiago, por poner un ejemplo. Ellos llevan muchos años a través de la CAM con herramientas para esto. Y sin duda ellos van a poder también empujar junto con ustedes este uso de herramientas a distintas organizaciones regionales que nos permitan ir avanzando con mucha fuerza. Y me parece que ahí hay un elemento muy interesante de lo que ustedes están haciendo con ODR Chile y el SIV Abogados. Quiero terminar solamente contando, para aquellos que no conocen un poquito, Fundación País Digital es una fundación 100% privada, nace hace 19 años en Chile, y lo que hemos hecho es empujar con mucha fuerza el desarrollo de la economía digital. Todos los socios que ustedes están viendo ahí son socios que con mucha generosidad van empujando a partir de la fundación lo que es el desarrollo de una economía digital en el país. Y eso es lo magnífico, porque es un tema muy chileno. Me ha tocado exponer en Europa, en Estados Unidos respecto a esto. No hay pares como este en el mundo. Si ustedes ven, están todas las empresas globales, mundiales, y nos ha permitido que el país pueda dar un salto tan fundamental hoy día en la economía digital. Y a partir del COVID, como lo hemos hablado, este laboratorio que nos ha tocado participar durante los meses anteriores, no me cabe duda que el salto va a ser mucho más rápido, que tecnologías como las que ustedes nos van a comentar hoy día van a ser muy necesarias para ayudar al desarrollo del e-commerce, para ayudar al desarrollo de todo lo que es a distancia y poder resolucionar disputas, naturalmente manteniendo lo más importante de esto, que es la fe pública, el hecho de que nos podamos unir con el Ministerio de Justicia, quien también está haciendo un tremendo salto en la digitalización de sus procesos. Con esto, Daniel, Gabriel, te agradezco. Quedo listo para poder entrar después en la parte de preguntas y respuestas, y muchas gracias por la invitación nuevamente.
Vale, gracias Pelayo, gracias por tu exposición. Creo que País Digital cumple un rol muy importante en Chile y me imagino, dado que se siguen sumando personas desde otros países, deben tener estas mismas complicaciones o problemáticas que afortunadamente aquí en el país podemos abordarla a través de la Fundación País Digital. Aquellas personas que se acaban de ingresar, bueno, ante todo, gracias por estar conectados. Ahora vamos a pasar con la parte de inglés, con lo cual pueden elegir la herramienta para seleccionar el idioma de intérprete. Así que, bueno, lo pueden seleccionar en un botoncito que está ahí por debajo, así que pueden elegir español o inglés. Ahora vamos a pasar a Collin. Collin, si quieres tú ir poniendo la presentación. Collin es CEO de mediante.com. En 2011 cofundó Modria, un proveedor de resoluciones de disputa ODR. Veo que también Collin ha escrito unos libros, tiene mucha historia en el mundo de ODR. La verdad que creo que estamos todos esperando a ver cómo nació y hacia dónde va el mundo de ODR. Así que, Collin, una vez más, bienvenido y gracias por tu tiempo.
Muchas gracias, Gabriel. Bienvenidos a todos. That's the end of my Spanish. Thank you very much for having me today. I'm actually a little sad that Pelayo's presentation ended because I was enjoying it so much. He set a high bar, but hopefully I'll be able to maintain the quality here. I'm delighted to be here with all of you alongside two of my very valued colleagues, Mike Dennis, who I worked with at Uncitral and APEC and now at the ISO, and Jamie, who I collaborated closely with at Tyler. So let me share my screen here. Hopefully, if I push the magic buttons, it'll all work. Great. It appears so. So I'm going to take 15 minutes to just talk a little bit about the developments in online dispute resolution around the world. Pelayo's actually the numbers that he shared about the developments in Chile are extremely encouraging. And I must say, sitting here in Silicon Valley, I am jealous of the amount of cooperation that's occurring between all the technology companies in Chile, because here it's just ruthless competition. But the good news is, I think things are headed in the right direction. And again, his statistics were much more specific and illuminative than mine. This is a similar kind of study that we've done in the United States from the Pew Research Center on Internet and Society that shows in the United States about 90% of US adults access the internet on a daily basis. And I think as Pelayo mentioned, a lot of that is mobile devices. We see broadband internet spreading. So the point is if you're not online, you risk increasing irrelevance. Industries that have not made the jump to the digital world are being marginalized. And as Pelayo mentioned, the pandemic has accelerated all of these factors. The younger generation in particular, if you're not delivering services online, they will go invent a new company to compete with you. And we've seen this innovation happen in medicine. We've seen this innovation happen in finance and in entertainment. But traditionally, the law has been a little bit behind. The justice system has not adopted technology in the same way as some other industries. And that's because the justice system is not subject to the same competitive pressures. But we're starting to see some cracks in that. And one of the things that is a big phenomenon in this space is online dispute resolution. So many of you might have heard of alternative dispute resolution or face-to-face mediation or arbitration. ODR essentially is the same thing. It's just the use of information and communication technology to help people resolve their disputes. Not only resolve their disputes, but also prevent and manage their disputes. Now, we're starting to hone this definition down a little bit. In the United States, the National Center for State Courts actually defines online dispute resolution as, quote, a public-facing digital space in which parties can convene to resolve their dispute or case. So you can think about this almost like an online room, a digital room that's created and optimized around the needs of parties to help them reach resolution in their cases. Now, dispute resolution traditionally has been outside the court system. But now what we're seeing is courts are starting to embrace some of these tools and bring them inside. ODR was originally created to meet the needs of e-commerce companies. And I was the director of online dispute resolution at eBay and PayPal. We resolved over 60 million disputes per year through a product we built called the Resolution Center. And that actually is more cases than are resolved through the United States civil court system. So we got to the point where 50% of those cases were resolved amicably between the buyer and seller, meaning they just worked it out themselves. And 90% of those cases were resolved without an eBay or PayPal employee having to touch the case. So it was only software working together with the two parties to provide a resolution. And the other point that's important is, you know, eBay works all around the world. So it wasn't subject to any one court system. Any participant in any of these disputes could appeal their outcome from eBay in a court. But 99.999% of these cases never made it to a court because they were relatively low value. And eBay enforced all of the outcomes automatically. So whenever the buyer was entitled to a refund, eBay, because we controlled payments through PayPal, we could take the money from the seller and give it to the buyer. So the disputants didn't find it necessary, actually, to go to the public justice system to get redress in their cases. And what we realized was the tools that we had built at eBay were useful for many other kinds of disputes as well. Of course, any online collaborative economy company, if you think about Airbnb with host and guest disputes, if you think about Uber and Lyft with rider and passenger disputes, they all needed online dispute resolution to resolve those issues. But we started to get pulled into things like consumer cases offline. Consumer protection cases. And then we were pulled into the insurance industry to do insurance reimbursement disputes, or even public disputes like property tax assessment appeals. But it was probably inevitable that at some point we were going to get pulled into the court environment more firmly. And that was why I think Tyler and Modria worked together to build essentially the largest court ODR system available in the world and most sophisticated, because that was what courts wanted to do. They wanted to leverage some of the same tools that we built at eBay to resolve cases that were coming in from citizens. So what we've seen in ODR, when we first started back in 99, 2000, we just imitated face-to-face dispute resolution. But over time, what we've seen is technology has shown us there's many new things you can do with technology in helping to resolve disputes that are very powerful and are if not impossible, at least highly impractical if you try to do them face-to-face. So these are the main components we talk about in ODR. Problem diagnosis, helping people kind of understand the situation that they're involved in and think about possible resolutions. Direct negotiation, where the parties communicate directly with each other to work it out, but technology can structure that negotiation. Mediation, where a third party assists the negotiating parties in finding a mutually agreed upon resolution. And then evaluation. Now note, I don't say arbitration. Arbitration is one form of evaluation, but there are many ways that you can provide an evaluative outcome, kind of like a judge coming in, listening to both sides and rendering a decision that is not actually arbitration, not necessarily enforceable in a court, but that may be privately enforceable. So what the interesting thing about these dynamics is problem diagnosis and direct negotiation, that's all software. That is software working with the parties. And if you build these systems in an efficient way and they become learning systems, you can resolve many cases, 60, 70, 80% of the cases, potentially even 90% of the cases in software. So you only need to rely on the human mediation and evaluation options in a small volume of cases. So essentially what we see is these tools are evolving rapidly. As technology extends its reach. So we're starting to see new approaches like smart contracts and blockchain, even artificial intelligence and machine learning to be leveraged in online dispute resolution. And what that means is we can lower the cost, increase the efficiency, so time to resolution decreases, and we can get more satisfaction and more fairness and consistency for the parties. So it's very exciting to see technology continue to evolve, because as computer processors become more powerful, as global networks become faster, that means online dispute resolution is going to become more and more effective and efficient and deployed. So what I wanted to take a little bit of time to talk about is this concept we have in online dispute resolution of the fourth party. Now, sometimes people can be a little weirded out by this idea, so I put a happy little picture of a robot there. So you can picture it as that happy robot. Essentially, the fourth party, if you think in a dispute, you have party 1 and party 2. Those are the disputants. And then you have party 3, who is the mediator, the human mediator, or the human arbitrator, that is a neutral to help the parties reach a fair outcome. The fourth party is technology. And it's almost like technology has a seat at the table in an online dispute resolution process. Traditionally, we've relied on technology to do very mundane things, administrative tasks, send reminders, or manage our calendar, or keep track of all of our documents. And that can deliver efficiencies in terms of saved money and time. But the point I'm making is, as technology becomes more complex and more sophisticated and more competent, that means the fourth party becomes more competent. And we may rely on the fourth party to do more and more as we get comfortable with technology's role in resolving our disputes. And eventually, I think the fourth party is going to be able to do things that a human third party either can't do or probably shouldn't do. And the fact that mobile phones and the internet are online 24/7 and always in our pocket, it really increases access and convenience for the parties. So if we ask ourselves, what do we ask fourth parties to do today in online dispute resolution and in the justice system more broadly? Obviously, making it easy for people to report their problem and diagnose their problem, provide advice to them about what options are available and how long a process is going to take and what information they need before they begin. Processing payments is something that technology has gotten very good at. Administering cases, sending out notifications, as I mentioned, managing documents, calendaring and scheduling sessions, particularly when you have lots of different people, all that need to be scheduled. Algorithms are quite good at that. And even assisting negotiation to provide a structure to the conversation between two parties to ensure that the negotiation doesn't run off the rails, where people just engage in threats and insults with each other and then they hit impasse. So the fourth party is very good at all these things today. But what's really interesting is what's going to be the capabilities of the fourth party tomorrow. And what we're seeing is the fourth party is getting very good at doing research. So if you have a landlord-tenant case, you can say to an algorithm, go out and read 10 million landlord-tenant case outcomes around the world and come back and tell me what you learn. That can really help parties understand and evaluate their case and establish what we call their ZOPA, their zone of potential agreement. Setting those expectations around reasonable resolutions is something that technology is very good at, and that can be very helpful in achieving consistent and fair and satisfying outcomes for disputes. The fourth party can also coach people, help them be at their best, and provide advice to them, strategic advice over the course of their conflict to ensure that they feel like they get the best outcome that they can. Technology is also going to be able to reframe our understanding of our cases and help us understand what we call our BATNA, our best alternative to a negotiated agreement. Because oftentimes the offers that we make in a negotiation are highly dependent on what alternatives we have towards that negotiated outcome being achieved. Also, we're going to start to rely on technology a lot to do enforcement when an outcome is achieved. So just like at eBay, where eBay could move the money automatically based on the outcome of a case, we're going to rely on the fourth party to do similar things. Also, document drafting and submission, e-filing documents, auto creating complex legal documents, that's something technology is getting better and better at. And we may eventually require agents, software programs that we inform what our preferences are. We will actually empower those agents to go out and negotiate resolutions to disputes on our behalf, and then bring them back and make sure that we're okay with them. So we see all of these things happening now in ODR, but the only way that we're going to be able to get to this future is for us to invest in the deployment of the fourth party and ODR with the capabilities we have today. So another thing I'd like to talk about is the ethical standards we are developing for online dispute resolution. This is ICODR, the International Council for Online Dispute Resolution, which promotes best practices and standards of practice for online dispute resolution service providers and platform designers. And we have a series of ethical standards that we're promoting around the world to ensure that ODR lives up to the high standards of justice that we have for public channels of redress. So that's the end of my comments, and I very much look forward to hearing your questions. Let me stop my share here. And with that, I will hand it back to Gabriel. Thank you very much.
Gracias, Collin, por tu tremenda exposición. La verdad, tremendo contenido. Algo nuevo para mí que estoy aprendiendo. Así que ahí hablábamos con Pelayo en privado, digamos, todo lo que implica el tema de ODR, ¿no? Y todo el camino que hay por delante. Y es bueno saber que el gobierno y las instituciones de alguna manera están trabajando en la materia para poder hacer que la tecnología tenga su impacto. Ahora vamos a pasar a Mike Dennis. Mike, si quieres tú poner la presentación mientras te hago la introducción. Mike Dennis es asesor principal de Kozlowski National Law Center. Se desempeña como consultor legal del Comité Económico de APEC para el desarrollo del marco colaborativo y las reglas del procedimiento sobre ODR. Así que lleva mucho tiempo en este mundo, así que vamos a dejar que Mike nos cuente un poco cuál es su visión y cuál es la visión de APEC.
Thanks so much, Gabriel, and hi, everyone. It's a privilege to be here, and it's a privilege to be part of such a great panel. Today, I'm going to talk about the ODR Collaborative Framework for Online Dispute Resolution, which was adopted by the Asia-Pacific Economic Cooperation Forum, APEC, in August of 2019 in Portoveros, Chile last year. Imagine you're a small vendor embroiled in a dispute with a foreign business in APEC. You argue back and forth, but you cannot find a common solution. You feel annoyed and frustrated, and at the same time, you worry about your business relationship. So you ask Apple Siri or Google or Alexa, what do you think a fair resolution of the dispute is? And Siri crunches through millions of cases and says, a fair resolution is full payment for your product plus shipping costs. What we're describing here is the not distant future. It's the fourth party, as Collin mentioned. In fact, artificial intelligence is already used in this manner for certain types of disputes in APEC. The internet and communications technology are changing every aspect of our lives, particularly during COVID-19. Now, AI-backed ODR is set to revolutionize commercial dispute resolution across APEC, thanks to the adoption of the new ODR Collaborative Framework. In this presentation, we'll look at the challenges facing APEC small businesses and how the APEC ODR Collaborative Framework brings a much-needed solution to improve justice and boost trade. Let me start with a few facts about APEC. APEC represents 38% of the world's population, 50% of the world's trade, and 68% of the world's gross domestic product. It's 21 member economies. We call them economies rather than states. The 21 member economies include Australia, China, Chile, Japan, South Korea, Indonesia, Mexico, Peru, Russia, and the United States. Its goals are free trade, regional cooperation, and economic growth. The Economic Committee, or EC, is a key pillar of APEC. It engages in structural reform, including economic and legal infrastructure, and the ease of doing business framework. The EC has studied the use of ODR since 2016, following the adoption of the UNCITRAL technical notes on online dispute resolution, and it's now working on implementation of the collaborative framework. Here's an outline of the collaborative framework, and I'd like to briefly go over each of the elements, and let's start with purpose. Here you see the text of the collaborative framework on purpose. At paragraph 1.2 states, the ODR collaborative framework creates a framework for business, in particular MSMEs, micro, small, and medium-sized enterprises, in participating economies to provide ODR through negotiation, mediation, and arbitration for business-to-business claims. Of course, negotiation, mediation, and arbitration are traditional dispute resolution mechanisms, but what the APEC ODR collaborative framework anticipates is the use of technology, including AI, to automate these traditional dispute resolution methods. Why does APEC even need ODR? Well, APEC small businesses account for 97% of the businesses in APEC. Small businesses employ over half of the workforce, yet they account for only 35% or less of direct exports. APEC MSMEs' expansion to international markets is crucial for their continued growth and APEC economy's well-being. A recent APEC survey of APEC businesses found that lack of dispute resolution was the major reason why small businesses abandoned cross-border trade. It's a major problem for 58% of the respondents. In emerging economies, that number rose to 74%. European Union studies have shown the same thing. 35% of cross-border disputes involving EU MSMEs remain unresolved, with the average value of the dispute being some $50,000 US. Studies also show that the vast majority of disputes are about payments. Small businesses are particularly vulnerable to late payments because their cash flow and access to credit lines are limited. Dispute resolution is a key component of a seamless legal system for trade. As one APEC business representative stated, pushing small businesses into the unfamiliar world of global value chains without contracting skills and access to commercial justice is like ordering soldiers out of trenches armed with baguettes. Theoretically, MSMEs could turn to courts to resolve their cross-border disputes, but APEC courts are too slow and expensive. According to the World Bank's Ease of Doing Business enforcing contracts, it takes on average 440 days to resolve a simple contract dispute in APEC involving an MSME at a cost of nearly 37% of the value of the claim. In Chile, it takes on average 519 days to resolve a simple contract dispute. The problems are worse in cross-border disputes because courts are too tied to geography, jurisdiction, and in-person enforcement. And now with COVID-19, many courts across APEC are closed. What about arbitration? Well, most large companies turn to in-person arbitration for their cross-border trade disputes as the only viable alternative. Under one recent survey, 97% of the respondents reported that in-person arbitration was the preferred method of resolving disputes in cross-border trade. But in-person arbitration is too slow and expensive for MSMEs involved in cross-border disputes. In another related survey, 3/4 of the respondents favored simplified procedures for claims under $500,000 US. As a friend of mine in the arbitration business told me, micro businesses couldn't afford the coffee at most arbitration centers. For MSMEs, simplified procedures are essential, and we can provide those simplified procedures through the ODR collaborative framework. How's the private sector handling ODR in the APEC region? Well, as Collin mentioned, ODR is already successful in other commercial contexts across APEC. As he mentioned, eBay processes 60 million disputes every year using only automation in 90% of the cases. Several ODR providers offer ODR for domain name disputes, including WIPO. In New Zealand, Fairway Resolution is launching ODR for commercial building and construction disputes. In the US, AAA uses ODR to resolve New York no-fault insurance disputes. APEC courts are turning to ODR, including for small claims. However, none of these initiatives has provided a solution for APEC small businesses engaged in cross-border commerce. In the right-hand column, you see a number of ODR providers that have expressed an interest in partnering with APEC on the collaborative framework, and there are a number of others that are interested as well. That concludes our discussion of purpose. Let's now look at the remaining elements of the collaborative framework, starting with the procedure rules. Here's an outline of the procedure rules. APEC created the procedure rules to ensure that the parties receive the same standard of due process regardless of where they're located. The rules cover all aspects of the ODR process, including procedures for the appointment of the neutral and the conduct of the ODR proceedings. Under the collaborative framework, ODR providers partnering with APEC agree to follow the procedure rules. The rules are based upon two UNCITRAL texts, the UNCITRAL technical notes on online dispute resolution, and the UNCITRAL arbitration rules. The rules apply by agreement of the parties. The rules cover business-to-business disputes to a sales or service contract. The annex also contains a model ODR clause for contracts for the parties to agree to use ODR. Section 3 of the rules is stages. The collaborative framework and procedure rules provide for the use of negotiation, mediation, and arbitration. This is what Collin talked about. The various stages act as a funnel so that only a few cases need to escalate to an online arbitrator. This way, most disputes can be resolved by negotiation or mediation. The negotiation phase is managed entirely by software for speed, efficiency, and cost effectiveness. If no settlement can be found, the case may escalate to third-party resolution. The ODR provider selects the neutral from a list of approved neutral. The online neutral provides online mediation, and if necessary, online arbitration. Including binding arbitration as a backstop serves as a strong incentive for the parties to settle earlier. That concludes our brief review of the rules of procedure. Let's now look at the remaining elements of the collaborative framework, starting with the role of the APEC Economic Committee and economies. Economies opt into the collaborative framework. There's no binding commitments. It's important for economies to opt in so that their ODR providers can partner with APEC. Thus far, China, Hong Kong, China, Japan, Singapore, and the US have opted in. The basic idea is that APEC would partner with ODR providers in offering ODR. The Economic Committee will maintain a list of providers on its webpage that have agreed to process claims through ODR as provided in the procedure rules. The Economic Committee and economies will also play a limited role in oversight of ODR providers. If an ODR provider is not in compliance with the rules, the Economic Committee may remove the ODR provider from its list. The Economic Committee is looking to academic institutions for help in evaluating the providers, and several institutions have expressed an interest. ODR requires an online platform for generating, sending, receiving, storing, exchanging, and processing communications. The Economic Committee decided that it would partner with ODR providers that are willing to provide their own platform. Partnering ODR providers are responsible for process issues, including fairness, due process, transparency, accountability, neutral appointment and selection, and the performance capabilities of the ODR platform. The ODR providers would agree to follow the procedure rules. They'd also agree to charge fees proportionate with the amount in dispute. The collaborative framework also provides that APEC economies will encourage their businesses, especially MSMEs, to use the ODR providers. APEC has a crucial role to play in promoting ODR to MSMEs, governments, and the legal community. Surveys show that microenterprises tend to work without clear contracts and dispute resolution clauses, which leaves them vulnerable in case of a dispute. Widespread adoption of ODR would promote a culture of contract. In turn, it would make transactions more efficient, driving down risk and making MSMEs more competitive by lowering cost. The collaborative framework also attempts to ensure that the relevant rules, procedures, and enforcement of online arbitration award is harmonized between economies. A strong legal framework already exists. Now, all APEC economies have implemented the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards. 18 out of 21 economies have implemented the UNCITRAL model law on international commercial arbitration, and 20 out of 21 APEC economies provide for legal recognition of e-signatures and e-contracts consistent with the UNCITRAL model law on e-commerce and the UN Convention on the use of electronic communications in international contracts. That concludes our brief review of the collaborative framework. The next step is for more economies to opt into the framework to ensure that their ODR providers can partner with APEC. The Economic Committee will host a workshop in Tokyo in January of 2021 to further promote implementation of the framework. ODR e-justice is an essential component of economic growth in APEC. Use of ODR modeled on the collaborative framework promises MSMEs access to commercial justice with tailored procedures that bring down cost, delays, and burdens in proportion to the economic value at stake. It will benefit the millions of small businesses who do not have access to effective dispute resolution remedies. It will help the most vulnerable MSMEs, such as women-led businesses, compete and flourish in the global value chain. ODR is the cornerstone for the next global justice system in APEC. Thank you for listening, and I'm available for questions.
Bueno, gracias Mike por tu presentación y ahora vamos a pasar con la última presentación a cargo de Jamie. Jamie es la gerente general de la plataforma ODR de Untitled Technologies con el producto que se llama Modria y bueno, mientras ella carga la presentación como director ejecutivo de ODR Chile, quería agradecerte por la confianza que han tenido en nosotros y en especial en el país, en tener la oportunidad de poder representar a Modria acá en el país, así que Jamie, es todo un placer poder tenerte aquí y que compartas con nosotros y con la audiencia un poco tu visión. Gracias.
Well, let me go back here. Thank you all for having me. I appreciate the opportunity to be here. You know, we really, as we talk about ODR in the U.S. justice system, we really think that technology is everywhere. We understand that you know, we really have technology as we go to do our airfares and we're flying. If we go to the bank, anything that we're doing, we pretty much are able to do that from our phone or definitely from a desktop. But if you take a look, this is an example of a, you know, imagine just pulling a doctor from an OR that was 100 years ago and putting him into an OR of today. And he really wouldn't even know where to start. As you can see in the image, the doctor on the right isn't even near the patient. They're several feet away and working on the patient that's laying on the table. But over on the left-hand side, this is what it used to be like. They were right there at the table. They're working together. And there's really just such significant growth in modern medicine over the last 50 to 100 years. But if you take that same approach and you try to apply that to the legal system, on the left, here's an attorney that was practicing law, you know, 50 to 100 years ago, and then you put them into a courtroom of today, and they would be able to function relatively well. really the justice just hasn't advanced at near the pace that the medicine has. And really, there's no better time than right now when we're facing a global pandemic to start rolling out and embracing technology in the judicial system. And, you know, we've talked about, Collin mentioned when he was starting, he talked about how eBay and e-commerce has really started using that. And really, we started seeing the justice system started being a little bit more open to ODR technologies probably 3 to 5 years ago. Obviously, with the pandemic, everything has accelerated. And so we're starting to see more and more of our customers willing to embrace new technology. So if you think about the Modria footprint around the world, you can really see that we're in more than 9 countries. The application is rolled out in more than 5 languages. And then within the United States specifically, we have well over 10 states that are using some aspect of the technology, some at a statewide level and some at just an individual court by court level. So we'll kind of talk about some of those a little bit more. And when you think about the different lines of business, you can see there's all different types. We kind of mentioned some of these throughout the presentation. There's some of the e-commerce with the airlines, telecom, retail, auto insurance, but then we also have some that are more in the judicial space, like landlord-tenant disputes, even things like property taxes when people are appealing the appraisal of their homes, marriage dissolutions and parenting custody arrangements. And really we'll start to see even more on the small claims and debt collection as we've had such a large increase of unemployment and people are unable to pay a lot of their bills and are continuing to rack up debt in order to kind of stay afloat. So we'll continue to see those grow. But really, it is not limited to these by any means. It's any situation where you have multiple parties that are in some level of dispute. So in 2018, the National Center for State Courts defined ODR for the U.S. justice system, and this is what they came up with as their starting point. So it was a court-related online dispute that is a public-facing digital space in which parties can convene to resolve their disputes. But they had a couple elements that had to be met in order for it to satisfy the requirements of ODR. It had to be exclusively online, meaning that it can't have a path to take the parties and bring them into a person-to-person or face-to-face situation. It had to stay online. It had to be designed to assist the litigant. So it can't be something that is focused on the judiciary and focusing on assisting the judges and so forth. It really needed to be for the parties and the individuals that were in the situation. And then the last one is that it needed to be hosted or supported by the judicial branch. So this was really to help make it where just individual companies didn't come out and start soliciting individuals to use their application in order to resolve a court dispute that maybe the court wasn't necessarily backing. So in 2018, Clark County, sorry, go to my next slide. Clark County, Nevada, which is Las Vegas, they started using the Modria application. And just to kind of give you a little bit of statistics about the jurisdiction, they have more than 2 million in population. They are the 12th largest county by U.S. population. And obviously that number changes drastically based on how many people are there at the casinos and able to visit the county. But they have a relatively large number of courts that they are working with, over 20 family courts that focus on nothing but the family cases, and then more than 32 courts that are driven on the criminal and civil side. And right now they have over 600 court employees that help manage those courts and help manage the litigants and guide them through their process. And this is kind of what their business process is that they were trying to resolve. So currently they have 11 full-time mediators that handle about a little less than 4,000 cases a year. The typical time frame from when a person is referred to the mediation center until they get their mediation appointment is somewhere between 3 to 4 weeks. And then the what they're working on specifically is their parenting plans. So they're focused on their custody, how they're going to exchange the children, the vacation time, holidays, and so forth. They don't really focus on any of the other aspects of the divorce. And their settlement range right now is about 70% for in-person mediation. And they wanted to be able to take this process online. They were having so many people coming in and out of the courthouse that they wanted to offer this in a way that people didn't have to make it down to the courthouse. And one thing that I didn't mention on this is these cases are strictly for any case where there is a child involved and it's a contested situation, so the parents cannot agree on it. This was not a tool that they wanted to implement just to help create the document that could be filed with the court, but they actually wanted this specifically for anytime the parents were unable to agree on how to handle the kids. So their process that they use is completely voluntary. So there's not any court order that requires them to use this online tool. They are under order by the court to participate in mediation. However, the ability to use Modry is completely optional for them. We currently have 59% of the petitioners that participate in this. Of those cases where the petitioner participates, we're getting 68% of the respondents that are going in there and actually responding to a proposed parenting plan that's generated by the tool. And then here is the outcome of those cases. So as you can see, 25% of the cases are getting to 100% completed parenting plan. So 1/4 of the cases that are going through this tool are coming out with the document that is required by the court to be a signed court order that can be filed back into their case, meaning that the parties don't have to go before a judge and negotiate any aspect of their case. They are completely done. They've done it all online. 65% of those cases are resulting in partial parenting plans, which means of the 8 topics that they're negotiating, like the way that they're exchanging the kids and what their holiday schedule is and how they're going to do their vacations, they are actually able to agree on more than 50% of those topics. And that what's interesting about that is it's allowing, once they get partially engaged in this process, when they do meet in face or in person with the mediator, they already understand what the mediation process is, and they're able to already kind of set aside the topics that they've agreed to and just focus with the mediator to help them on the few areas that they're unable to meet with or come to an agreement on. And then there are 10% that are going to have to go before a judge and have the judge order what's in the best interest of the children, because the two parties are just completely unable to agree. And, you know, one of the things that we really don't focus on a lot when we're talking about ODR, but not only is this advancing the technology of the judicial system, but it's really expanding access to those parties that may not have the ability to participate in the judicial system in the normal way. The tool, you don't use attorneys, it's just the parties that are negotiating with each other. In most of these situations in Las Vegas specifically, almost all of the agreements have been finalized outside of court hours. So it allows the parties to not be limited to an 8 to 5 Monday through Friday timeframe in which they can get their cases done. So they're not having to take time off work, they're not having to find childcare for their children, but they're able to still get a resolution to their situation. So when you think about the average time to resolution, and these times are pre-COVID, actually now they're even better for ODR, but the court, due to being closed for several months, the time to trial is extended pretty significantly. But before COVID, in the court, it would take about 8 weeks for them to get a trial from the time they requested a trial date. It was about 3, sometimes 4 weeks before they were able to get an in-person mediation appointment. But when it comes to being able to use and complete ODR, it was 7 days on average. And really, we saw our fastest resolution in just a few hours. So the parties were able, again, when they're in a contested divorce situation, they were able to come to a resolution with just a few hours, and something that should hopefully be the most important thing that they're negotiating, their children. So as I said at the beginning, really the judicial system is lagging behind most other areas with the while embracing technology. But as you can see, I just put some recent screenshots here of the pandemic is really fast tracking that process and really allowing the courts to see, set aside some fear that they may have in embracing new technology and allowing them to say, hey, we've got to figure something out. The courts have been closed for, in some jurisdictions, already 4 months with no end in sight to when they may open back up to the public, but we can't allow justice to stop. So we're starting to really see the courts take on the technology and embrace that and expand that to their constituents. So thank you guys for having me, and I'll be here for any questions that you have.
Bueno, gracias Jamie por la presentación. Y ahora abrimos la sesión de preguntas, así que hemos recibido varias preguntas de la audiencia, con lo cual voy a seleccionar algunas acá y vamos a arrancar con Collin. Una pregunta que he recibido es, ¿cuánto tiempo cree que pasará antes de que discutamos nuestros casos ante un juez digital en lugar de un humano? ¿Cómo podemos asegurarnos de que estos jueces digitales sean justos si no podemos comprender las complejas reglas que dictan sus decisiones?
That's an excellent question, Gabriel, and I'm sure Mike and Jamie and I have heard this question many times as well. As artificial intelligence rolls out, there are a lot of optimistic projections about how quickly we're going to just kind of hand everything over to the algorithms to power the justice system. And you're right, the challenge with artificial intelligence and machine learning is that when we create these large data sets and we train algorithms by studying these data sets and writing their own rules, if we go look at the rules that the algorithms come up with, they're kind of gobbledygook for humans to understand. We can only evaluate the efficacy of these machine learning judicial approaches from their output. So we can't really understand the process that they're using, and that creates a lot of challenge. So there's a lot of studies now looking at how we can combat some of the bias that can seep its way into some of these algorithmic approaches. And I think it's going to take time for us to do that. I don't think we're going to be having digital judges within the next 5 to 10 years, maybe within 10 years. I think they say that the singularity, which is the moment at which one computer processor exceeds the power of the human brain, that's going to happen somewhere around 2031. So probably we have about 10 years, 11 years to the point where computers are going to have the level of sophistication that, say, a Supreme Court justice will. And I think there's going to be a lot of cultural change also that's necessary for us to get comfortable with computers playing that role. But it's not that digital judges are going to work the same way as human judges. We may rely on algorithms to do things like tell us which proposed solution is fairer or which is more consistent with global precedent. But we're definitely headed in that direction. I believe that our grandkids, or our great-grandkids probably, will never get a driver's license because they will be comfortable with algorithms driving all the cars, because it will be obviously safer. And I think that we will also get comfortable with algorithms playing a greater role in our global justice system as we start to rely more heavily on technology, because we will see through study that the outcomes generated by those algorithmic approaches are fairer and more consistent.
Gracias, Collin. Aquí recibí otra pregunta que, para darle un poco de continuidad con el tema de visión, esto es para Jamie. ¿Cuál es su visión del futuro acerca de ODR? ¿Hacia dónde va?
That's a great question. I really think we're going to see ODR as the new starting point within the justice system, at least within the U.S. justice system. I think that the court rules are going to start changing to where you have to attempt some level of party-to-party negotiation, and including with at least a third-party mediator before you're able to get in front of a judge and have the opportunity to have a trial. We may not see this in every single type of case that we see across the U.S., but we'll definitely see it in some of the less sophisticated, lower value cases where you don't even have the opportunity to speak with the judge until you've at least attempted this, because the backlog and the level of time that it's taking the judges to resolve these when they could be negotiated online and could be negotiated away from the court just doesn't even make sense.
Gracias, Jamie. Tengo una pregunta para Mike, que dice acerca de ODR. ¿Es una herramienta pensada para pequeñas o grandes empresas? Que ese es un tema que siempre la gente se pregunta, cómo estas soluciones aplican para cada industria o para cada tamaño de compañía.
Thanks, Gabriel. That's a great question as well. Well, APEC is focused on MSMEs because they're considered the engines of economic growth and job creation in an economy. But APEC recognizes as well that it's crucial to have large businesses involved, since small businesses contract with large businesses, and you have to have both parties agree to use ODR. I think in the survey that I cited, 3/4 of the respondents favored simplified procedures for claims under $500,000 US. So it's not just small businesses that can really benefit from ODR. APEC is looking to have the APEC Business Advisory Council assist in developing the collaborative framework, since it represents numerous businesses across APEC. That assistance will be crucial. I think ODR could be really useful for sectors like banking or construction. And as I mentioned, Fairway is implementing ODR for the construction sector. Thanks.
Gracias, Mike. Y acá continuando un poco ahora con el tema de las empresas grandes, chicas, esta pregunta va para Pelayo, que bueno, la Fundación tiene un alto impacto en los ciudadanos. Pelayo, ¿qué oportunidades y beneficios crees que ves para los ciudadanos en la implementación de este tipo de soluciones y herramientas?
Oye, primero felicitar a los panelistas.
First of all, I want to congratulate the panelists.
La experiencia de Collin, Jamie y Mike me han dejado impresionados en estas materias. Cuesta encontrar en el mundo personas que van adelantadas una década a ciertas situaciones. Y he visto en este panel eso, así que realmente los felicito. Desde el punto de vista de Chile, yo creo que Collin por ahí lo dijo. Esto es una transformación cultural. No tiene que ver, Gabriel, con tecnologías. Acá lo importante es cómo nosotros ponemos al ciudadano primero y adaptando las tecnologías que hoy día están, como lo hemos visto en este programa, habilitadas, podamos empujar la transformación cultural. Y eso es súper complejo, no es fácil. Tú tienes una resistencia al cambio que es brutal. Yo llevo 10 años como presidente de Fundación País Digital y los procesos de cambio en estas materias son lentas. Por ahí le preguntaste a alguien respecto al juez digital. Llevamos 40 años de inteligencia artificial y recién lo estamos tomando. Las olas tecnológicas son olas que cada día van más aceleradas, que el COVID nos aceleró, pero que nosotros tenemos que entrar en la transformación cultural de un país para lograr lo que se está proponiendo. Entonces, yo estoy seguro que esto para los ciudadanos sin duda tiene ventajas enormes, pero vamos a tener que pasar por el proceso de transformación cultural que esto implica. Hoy día vemos que el gobierno, como lo hablábamos, está acelerando la digitalización. Vemos que el sector de justicia, en el caso chileno, está teniendo grandes ejemplos de modernización. Quiero dar uno, por ejemplo. A mí me sorprende el conservador de bienes raíces de Santiago, cómo ha logrado digitalizar el 100% de sus procesos. Y lo nombro porque es algo similar a lo que tú estás mostrando acá. Es como una empresa de servicios al sistema judicial es capaz de acelerar. La Cámara de Comercio de Santiago, lo que está haciendo Macarena Letelier, sin lugar a duda, ha tratado de acelerar el proceso a través de la CAM. Entonces, lo que yo creo que vamos a tener que empujar, porque los ciudadanos van a ver los beneficios, sin duda, ya lo han mostrado Jamie y Collin en sus exposiciones, es cómo aceleramos el proceso. Y quizás me gustaría ahí interrumpirte, Gabriel, y preguntarle a Collin, a través tuyo, ¿qué nos recomendaría Collin para acelerar los procesos de transformación cultural en esto? ¿Dónde están esos elementos claves que según la experiencia de Collin han permitido que en otras experiencias de otros países, y perdona Gabriel que tome esa pregunta, podamos empujarlo?
Sorry, that's such a cliche to start speaking when you're on mute. Thank you for the excellent question, Pelayo. Actually, I would say Chile has the key ingredients to achieve this transformation much more effectively than many of the other countries that I've worked in. I think I was saying to Gabriel the other day on one of our pre-calls, many of my friends who have started online dispute resolution initiatives in Latin America, they have moved to Santiago because they know that Santiago is a place where private industry has a lot of flexibility to innovate. There's a lot of capital. There are a lot of future-oriented people in Chile who are thinking about, let's invent the future. You know, I come from Texas. Jamie and I, we both come from Texas. My grandfather always used to say, don't build your business where the highway is. Build your business where the highway is going. And I think that that's a little bit of Texas wisdom that is very true in this ODR conversation. What we see is government and the judicial system in particular traditionally lags innovation. It has to be pulled into the innovation because it's not subject to the same competitive pressures that for-profit industries are subject to. As I said, I'm jealous of the degree of cooperation that you have in Chile. Silicon Valley does not have that cooperation. Most of these big tech companies that you're talking about, from Facebook to Amazon to Microsoft to Google, they are engaged in enormous and aggressive competition. And they're constantly trying to one-up each other with new features and new innovations, because in Silicon Valley, it's all about the new thing. So I think what's happening is citizen expectations are changing. And those expectations are putting new requirements on government. It's not that government is innovating just out of the goodness of its heart, because a lot of these systems have worked well for years. So there's very little incentive to change them other than citizens are demanding it. And if citizens are used to 24/7 online services, if they're using Gmail, if they're using Facebook, if they're using LinkedIn, they're not going to tolerate the requirement that they drive down to a government office and stand in line and fill out a paper form. They're just going to reject that process, and they'll find a way to circumvent it. So the fact is, it's user demand that is driving this transformation, and the only way that the transformation can occur fast enough is for it to occur in the private sector. And that means many companies will innovate. There will be 100 innovations, and 99 of them will fail, but one will succeed. And then there will be a new wave of innovations. That's what we call creative destruction. And industry is the only entity that can move fast enough to keep up with these trends. And that's why it's so important for governments to partner, for public agencies to partner with private companies like Tyler and, for instance, Fairway, what Mike was talking about in the New Zealand context, because those organizations can move at the pace of innovation required to keep up with citizen expectations.
Gracias, Collin. La verdad que sí, un tremendo punto. Creo que, digamos, tenemos consumidores cada vez más exigentes, con lo cual este tipo de plataformas van a ser cada vez más demandadas y es un poco lo que decía Pelayo y tú, ¿no? O sea, esto es un tema de un cambio cultural y también entender que el consumidor de alguna manera demanda mejor calidad y bueno, mejores tiempos y mejores respuestas. Dándole un poco de continuidad a tu visión, esta pregunta va para Jamie, que acá me preguntan, y voy a juntar dos preguntas. Una dice, ¿qué plataformas concretas existen y se usan para estas resoluciones de conflictos? Y por otro lado es, ¿qué sucede con la confidencialidad de la información? Okay.
That's a great question. So just the platforms, there's several different opportunities out there on different platforms that you can use. We really try to focus mostly on the guided process, the guided walkthrough help between the litigants, so that we're not using much of the video chat or allowing the parties to chat. We're really utilizing some level of social science to ask them questions and to get answers, to try to pull out the emotion out of the case. And also because in many of these situations, the parties have already tried to negotiate unsuccessfully, just because in our nature, we don't really understand how to negotiate. So those are what we're focusing on. And when you think about something like what we're doing here with the video, while that's a great opportunity and a great option, we could be eliminating some of the citizens that need this platform, that really need the opportunity to be able to utilize this, because they just don't have the bandwidth or don't have the tools to be able to do some level of video. So we want to make sure that we're opening up this opportunity to as many people as we can. And regarding the confidentiality, that's a really good question. So the way that we're handling that is obviously throughout the negotiation process and the mediation aspect, any level of offers that are going back and forth, or even any discussion, cannot be shared with the court. We have to maintain that confidentiality, because otherwise we won't allow, the parties will not engage and feel comfortable in that process if they think that they say something through the negotiation and are unable to settle, that could potentially come up in the court. So we really are limiting what level of information that the courts are able to see through the process, and we allow them to see the beginning part where we're inputting the data of who the parties are and then what the outcome is of the resolution. And by the outcome, if they come to a resolution, we'll share all the information, because that's what then becomes a court order. If they don't come to a negotiation, or I'm sorry, a settlement agreement at the end, if they agree on some terms, we'll provide that. But if they don't agree on anything, we don't say anything at all about what the level of conversation was. We just simply provide an output that says they were unable to come to an agreement, so that when they get started, they're starting back at ground zero.
Ok, gracias. Otra pregunta aquí, dice, muy buenos días, felicitaciones por el seminario. Pregunta para Collin. ¿Cómo solucionamos la falta de imperio que puede tener un sistema ODR? ¿Cómo hacemos que la decisión o el acuerdo alcanzado mediante la plataforma sea vinculante?
Excellent question. I would say the number one determinant of the effectiveness of an ODR mechanism is enforceability of outcomes. And as I mentioned before at eBay actually ended up buying PayPal because eBay needed to manage the payments in order to enforce its outcomes. If you look at the effective global ODR systems, for instance, the domain name dispute resolution system run by ICANN, they have absolute enforcement power. When they render a decision about who should own the domain, they can change the database and reassign it. So you have to have the ability to enforce your outcomes in a timely and effective way in order to get the ODR system to matter. People constantly say to me, why don't you build an ODR system for a classified site like Craigslist? Well, the problem with those sites is you don't have any enforcement power. You don't really have any contact information for the other side. The transaction occurs in cash. If you buy a laptop and 2 days later it bursts into flames, you don't have the contact information for your counterparty, and you cannot reverse the funds because you gave them cash. So it is impossible to build ODR in a system like that. You need to change the marketplace to ensure that you have the ability to enforce your outcomes. Now in the courts, again, this is a problem with the judiciary. People will often get a decision from a court, and then they say, okay, here's your decision that says you're entitled to your money back. But then you have to go enforce that decision. And sometimes enforcing the decision is harder than getting the decision in the first place. I can build an ODR mechanism that says this person deserves refunds, this person deserves a replacement. But if I can't enforce those outcomes, the parties will be frustrated. Parties don't come to these ODR processes because they want to have a system that says they're right. They come because they want an outcome. And if you cannot deliver the outcome, your process is incomplete. So that's why I think people are talking about the creation of a new justice system, like with things like smart contracts and blockchain, because those agreements and outcomes are automatically enforcing. They are enforced by math, not by you getting some justice of the peace to go hunt down your counterparty and then somehow, squeeze the money out of them. So I think we need to get to a vision of a justice system that has enforcement integrated into it. And if you look at the payment ODR standards that we're issuing through iCoder, we insist that all outcomes be fully enforced 5 days after closure. And I don't think that there's any court in the world that can guarantee all of their outcomes would be enforced within 5 days. But we can do that with math. We can do that with code. And that's part of us envisioning a next better justice system.
Muchas gracias, Collin. Y acá tengo una pregunta para Mike. Continuando un poco con la dinámica de los consumidores, ¿cómo se podrían beneficiar a los consumidores con el uso de la plataforma y sobre todo tú, Mike, que tienes la visión de APEC, ¿no? ¿Cómo está impactando esto?
That's another great question. The ODR could be of tremendous benefit for consumers, and I think we've seen that in a number of platforms that have been established. Parle, for example, in Quebec, uses ODR for consumer disputes. It uses it during a negotiation stage and a mediation stage, and it's able to resolve 70% of the disputes in using just online negotiation and online mediation. And the satisfaction rate for that is about 80%. So that system has had tremendous success. Also, you see the small claims courts have business to consumer disputes, obviously, and they've been extremely successful as well. Those are mostly domestic disputes. When you move cross-border, it's much harder to enforce, as Collin was mentioning. If you buy something from an overseas vendor and you don't receive it, what do? You don't really have a remedy. APEC considered including business to consumer within the collaborative framework, but one of the major problems is that the laws for protections of consumers vary wildly. That's why many key private international law instruments that underpin the legal framework for ODR exclude consumers. But it would be really important for APEC to move to B2C disputes and economies to move to providing for resolution of B2C disputes in the future. Thank you.
Ok, gracias Mike. Bueno, para entrar al cierre, antes de dejarles un minutito a cada uno de los panelistas, simplemente a la audiencia le quería comentar, bueno, nosotros somos ODR Chile, yo soy director ejecutivo de la firma, y tenemos la representación de Moderador en el país, con lo cual a todos aquellos interesados estamos abiertos para poder hacer pruebas de concepto, pilotos o demos. Creo que es algo muy importante. Ya estamos trabajando hace poco que básicamente estamos en el tema, con la tecnología, digamos, pero ya estamos trabajando con algunas instituciones bancarias y nada, la invitación es a que nos contacten, trabajemos de la mano, en conjunto, creo que hay mucho para hacer, así que simplemente dejar ese mensaje. Y ahora, si les parece, les dejaría unos 30 segundos o un minutito, lo que ustedes deseen, a los panelistas, como para hacer el cierre de la jornada. Si quieres, empezamos por Jamie.
Thank you for the opportunity to speak and for this wrap up. I really think if we look back in, 5 years or maybe even less than that at what we're talking about today, we're going to really see such a transformation over the next several years as we now have to think about different ways to do the same thing that we've done in the past without being in crowds and without having lines and so forth. So I think this is such an opportunity for us to take advantage of what's not a good situation in our world and have some good that comes out of it. And it really advances the opportunities that we are providing for all of the people that we need to serve. So I just think, take the opportunity to kind of jump in and see what this is about. And I think that you'll be pleasantly surprised with how it transforms your business. Thank you.
Gracias.
Gracias, Jamie. Mike, continuamos contigo, si te parece.
Thanks very much. It's been such a privilege to be part of this panel with such great speakers. I think it's been emphasized this morning, COVID-19 has really brought about huge changes as far as dispute resolution is concerned, and hopefully we can continue that trend. It really underscores the importance of providing access to justice in cross-border disputes. I think the APEC ODR collaborative framework is a game changer in that regard. And hopefully we can have Chile opt into the collaborative framework in the near future. Thank you very much.
Muchas gracias, Mike. Collin, ¿qué nos puedes decir del Silicon Valley?
Thank you, Gabriel. Well, this has been an excellent conversation. It's a very high-powered panel. This is actually my first experience using Zoom for a multilingual presentation, and it's gone incredibly smoothly. So thank you to the organizers for doing such an excellent job. I would just say online dispute resolution to a certain degree is inevitable. And I'm very excited about ODR Chile. I think, as I said, there's a lot going on in Latin America. Brazil has passed a mandatory mediation law that specifically calls out online dispute resolution. ODR Latino America is based in Buenos Aires. But I actually put my money on Chile to move the fastest. I think in terms of the innovation culture, in terms of the strength of the private sector, and also this partnership, Gabriel, that you're headed up. I think it seems to me all of the ingredients are there for rapid innovation. And I think if we squint our eyes and look a little bit into the future, we can see that these tools are going to open up enormous possibilities for expanding access to justice, delivering fairness, expanding the reach of our justice systems, and that's going to help our citizens. So I want to encourage all of you to further your innovation and experimentation. We're going to need not just one ODR system. We're going to need ODR for construction. We're going to need ODR for debt collection. We're going to need ODR for elder mediation. There's going to need to be a flowering of innovation in this space. And I think we're going to look back on this conversation as sort of a watershed at the beginning of a long journey. Maybe we're starting a snowball rolling down the top of the hill. So we'll see if it turns into an avalanche at the end. But I'm delighted to have been able to engage in this conversation with all of you, and I can't wait to see what's coming.
Gracias, Collin, por las palabras, y bueno, creo que estamos todos también motivados en este tema, y bueno, por último lo dejo a Pelayo, un gran amigo, y aprovechando también para comentar del Summit, así que por eso te dejé último, Pelayo, para que cuentes, porque todo eso genera un impacto en la sociedad, y es un poco lo que Collin y Jamie y Mike comentaban, ¿no?
Muchas gracias, Gabriel. La verdad estoy igual de sorprendido que todos por este panel que hemos tenido. La verdad que ha sido un gusto y un honor haber sido invitado. Son materias que yo no entendía y he logrado entender a partir de ustedes materias totalmente nuevas. Y quiero tomar lo que dice Collin como una forma de amplificarlo. Probablemente en Chile tenemos un sistema judicial que funciona bien. Tenemos la Cámara de Comercio que ha hecho un buen trabajo durante los últimos años. Y lo que yo creo que ahora hay que hacer es expandir con mucha fuerza esto a nivel nacional. Yo comparto que acá hay muchas áreas en que podemos tener esa transformación cultural para como país, en regiones, en las cámaras, porque hay un elemento fundamental de esto que es la fe pública. Y con la fe pública no podemos jugar. Por tanto, en la medida que vayamos uniendo cada vez más este modelo tecnológico y que se vaya entendiendo en el correr de todas las regiones, no me cabe duda que va a ser un sistema que nos va a poder ayudar a acelerar con mucha fuerza el proceso judicial, el proceso de disputa y el proceso comercial. Yo siento que esto le da un empuje con mucha fuerza al e-commerce y que sin lugar a duda, producto de la pandemia, ya se aceleró y ahora tenemos que ir resolviendo ciertos elementos técnicos. Uno de ellos, solo para terminar con un ejemplo, uno de los desafíos más complejos que hubo, por ejemplo, en la telemedicina, no fue la tecnología de la telemedicina, fue que en Chile los seguros para poder tener esa consulta a distancia no estaban preparados para que yo pudiese pagarla. Y por lo tanto, estando la tecnología presente, no podía tener una consulta porque no tenía esa capacidad. Yo creo que acá lo que nos permite este sistema es sin duda acelerar con mucha fuerza el e-commerce a futuro, así que bienvenido y cuenten con todo el apoyo de Fundación País Digital para poder desarrollarlo. Y nada más, una invitación a todos los que están escuchando, aprovechen este martes y miércoles, vamos a tener un summit a nivel nacional, más presidido por el Presidente de la República, Presidente de la Corte Suprema, a propósito del tema de justicia, con la gente de la Presidencia del Senado, más de 7 ministros, 12 subsecretarios y 125 CEOs y directores de las grandes compañías hablando sobre la transformación digital post-pandemia. Creo que es una oportunidad para que todos aprovechemos de aprender la importancia que implica hoy día esta transformación cultural que estamos viviendo. Así que invitados todos a meterse ahí a paisdigital.org o a través de los distintos canales que van a ver, EMOL, TVN, vía telefónica, vía BTR, etc. Muchas gracias, Gabriel, por esta invitación.
Bueno, para agradecer a todos una vez más, gracias a todos los que se conectaron, hemos tenido de todos los países, hasta de Singapur también hemos tenido ahí dentro de la audiencia, así que a los panelistas una vez más, muchísimas gracias, creo que fue espectacular, así que nada, un saludo para todos y que estén muy bien. Chau, chau. Gracias.